Hello, I am Alicia Christie. Welcome to my law channel. Today we'll be discussing a very interesting area in criminal law. Today we'll be looking at what is a crime and what are the elements that make up a crime. To begin, we will look exactly at what is a crime. A crime is any act performed by an individual which is considered to be prohibited by law. Who can be criminally liable for offenses and who cannot be held criminally liable for offenses? For a person to be held criminally liable for an offense, that individual must have performed the Actus Reus and the mens rea of a crime. Generally, that person must have an appreciation of the act or the result that he has brought about. So, for the purposes of the law, children are conclusively presumed to not be able to be criminally liable by the law. This is found under Section 63 of the Child Care and Protection Act, as well as mentally insane persons are considered to not be able to form the relevant mens rea of the crime pursuant to the Criminal Justice Act. Let us move a little bit further into what are the elements that make up a crime. As was indicated earlier, in order for a crime to be established, it must be shown that there was the Actus Reus and the mens rea, and both the Actus Reus and the mens rea of the crime must coincide. The Actus Reus simply refers to the guilty act, a positive act that the defendant has performed which brought about a desired result. The Actus Reus need not only be a positive act pursuant to the law, it can also be omission, where an individual has failed to do a particular act, having been brought under a contractual duty to act or otherwise. As well as an act can also be brought about by an automatism, or a person who loses control of that which he usually has control of. Let us look closely at what are the things that make up the Actus Reus. For the purposes of this channel, we will look at willed conduct. Where a person's conduct is deemed to be willed, it simply means that that person would have positively acted in bringing about a particular course of action. The exception to this rule is an automatism. The test that is laid down for automatism is that there must be total destruction of a voluntary act. In the case of Bratian AG, the court stated that a person is in an automated position where that person loses control of the thing that he usually exercises control over. So, let us look at this example. If it is that I am driving down the road one day and my windows are down and a swarm of bees flew into my vehicle and attacked me, causing me to hit persons who are on the roadway, resulting in injuries and death. The first thing that the court will look at is whether the act was voluntary. Now, in this particular case, the act would not have been voluntary simply because I was not in control at the time that I ran into these people, causing the injury and the death. It was interrupted by a swarm of bees who had attacked me. So I would not be liable because the Actus Reus would not have been made out on the facts of the case. Let us look now at omissions. Persons are not only liable where they have done a positive act, but liability can also arise where an individual fails to act. That individual must come under a duty to act, whether it be by a contractual obligation that he has, or it is by voluntary assumption of responsibility. In the case of R versus Pittswood, the court basically stated that the defendant was liable on the basis that he had failed to perform his contractual duty. The facts of that case are that he was supposed to man the railway track. So he was supposed to ensure that incoming and outgoing train, the gates were properly manned. So he was supposed to ensure that he closes and he opens that gate. On one particular occasion, he failed to perform his duty, resulting in somebody being killed on the railway. The court said that he had a duty to act and he failed to act. Let us now look at the case of R versus Stone and Dobson. It is a very important case because it shows that where an individual voluntarily assumes responsibility, then that individual might be made liable where he fails to perform. The failure to perform in the case of Stone and Dobson arose based on the fact that these family members assumed the care of their family member, and in assuming that care, they had a duty to ensure that he was properly taken care of. However, they failed to ensure that he was taken care of and he subsequently died. The court said that the liability arises on their part because they voluntarily assumed responsibility and failed to meet the standard that was required in order to take care of their family member. Let us now look at what is considered to be very important in law. We have causation in law and causation in fact. In order for a defendant to be made liable for any offense, that it must be proved by a competent court that there was causation either in law or in fact. Causation in law refers to the but-for test. If the act or the offense would not have occurred but for the act of the defendant, then no causation would have taken place. In R versus White, the court had this to say. The court basically said that the son was not liable for his mother death because at the time of her death, she had basically died from a heart attack as opposed to the canine that was placed in her milk. Thank you.